Good afternoon, everyone. Thank you for being here. My name is Kongsatja Suwanapech, and I have a pleasure of moderating today's public lecture. We are honored to have with us Professor Paul J. du Plessis from the Universities of Edinburgh, who will be speaking on Savigny, Marx, and the natures of law. Before we begin, I would like to invite Associate Professor Supriya Galaiet, Dean of the Faculty of Law, to deliver the opening remarks.
Good afternoon, everyone, distinguished guests, colleagues, and students. This is my great pleasure on behalf of the Faculty of Law, Thammasat University, to welcome Professor Dr. Paul J. du Plessis from the University of Edinburgh and all of you to today's public lectures, Savigny, Marx, and the Nature of Law. We are honored to host such a distinguished scholar, and I would like to thank everyone who has made the time to join us here this afternoon. At our faculty, we value opportunities to bring the law into conversation with ideas from across places, times, and traditions. Such encounter not only strengthen what we already knew well, but also open shared possibilities, inviting us to imagine the law in ways that reach beyond the familiar. Law, after all, is more than the sum of its rules, but is a living dialogue with a society itself, shaped by history, philosophy, and culture, as much as by legislations and courts. When we approach law in this way, we discover both the foundation we rely on and the path still to be explored. Professor du Plessis' scholarships reflects this spirit. As chair of Roman law at the University of Edinburgh, he has devoted his career to exploring the relationship between law and societies, with particular expertise in Roman law, properties, obligations, and the us commune of the late Middle Ages. His relationship engages deeply with legal history, drawing on Roman law and the intellectual traditions of figures such as Savigny, Sir Henry Maines, and Marx to explore the nature of law. Today's lectures offer more than a window into the past, but it is an invitation to consider how history might illuminate the present and how the present might open new possibilities for the future of law. I hope it will spark curiosity, encourage reflections, and remind us that the law's strength lies not only in its certainty and consistency, but also in its capacity to adapt creatively to the questions and challenges of its time. Finally, I would like to express my sincere gratitude again to Professor du Plessis for kindly giving this special lecture, and also to Dr. Kongsatja for organizing this event. Thank you, everyone, and please join me in warmly welcome Professor du Plessis. Thank you.
Thank you, Dean. The honor is entirely mine. It's good to be back at this wonderful law faculty. This is I think my third visit properly, and it's always such a wonderful place to come back to, and so many stimulating conversations to have with colleagues about all things Thai law, Thai legal history. My paper today arose out of a larger project of which I'm part, which considers the impact of classical antiquity upon the thoughts of Marx. The consequences or the output from this project is going through peer review at the moment and will probably be published later in next year or so as a book which engages systematically. Not my own book, but I wrote one of the chapters that engages systematically with Marx's ideas of classical antiquity and how he uses classical antiquity in his own legal thinking. And I wrote about Marx and the law and Marx and classical antiquity, and so what I will present today is a version of that to give you a flavor. We start our story not with Marx, but with Edward Gibbon, the famous English historian. So I start with a quotation from Gibbon, and this is the quotation: "Wise or fortunate is the prince who connects his own reputation with the honor and the interest of a perpetual order of men." So wrote the English historian Edward Gibbon in chapter 44 of his Decline and Fall of the Roman Empire, published in several volumes between 1776 and 1789. Now, this short quotation, which I've taken from his chapter on the development of Roman law, is filled with insight and may be read on one level as a summary of the development of law in Europe from the late medieval period onwards. It was the discovery, or rather rediscovery, in northern Italy during the 12th century of the Corpus Juris of Justinian, together with the rise of medieval universities and the academic teaching of law at these universities, that would leave such an indelible imprint on the development of law in Europe, even down to the 18th century when Gibbon wrote his work. Now, in the intervening period, Roman law had fulfilled many different functions. Not only did it provide a set of ready-made rules of law, which could be adopted by popes, kings, and emperors to create their own national legal systems, but the ideologies of empire could also be drawn upon to bolster their power and prestige as the inheritors of Rome. Although Roman law as a legal order from antiquity fundamentally shaped the legal landscape of the European continent from the late medieval period onwards, it was not in any sense viewed as history in that period, however. This is because history as a distinct academic subject with its own methods and province did not exist until the 19th century. There was, of course, an increasing awareness of the idea of history from the 16th century onwards, when scholars of the Renaissance began taking an interest in Greco-Roman antiquity, and specifically in the authors from this period whose books had survived in manuscript form. However, history as an academic subject did not emerge until the 19th century. Before then, it operated within the context and in the service of traditional professional disciplines which dominated university education in the late medieval period and beyond, namely law and theology, where, to borrow a phrase from the Enlightenment thinker Henry St. John, 1st Viscount Bolingbroke, history was, and I quote, philosophy teaching by example. Although, as David Hume, the Scottish philosopher, put it in his Inquiry about Human Understanding, published in 1748, and I quote here again, "Would you like to know the sentiments and course of life of the Greeks and the Romans? Then study the temper and the actions of the French and the English. You cannot be much mistaken in transferring to the former most of the observations which you have made with regard to the latter. Mankind is so much the same in all times and places that history informs us of nothing new or strange in this particular. Its chief use is only to discover the constant and universal principles of human nature by showing men in all varieties and circumstances and situations, and furnishing us with materials from which we may form observations of our own and become acquainted with the regular springs of human action and behavior." End quote. So, in a paper devoted to antiquity, the inheritance of Greece and Rome, upon a 19th century intellectual such as Karl Marx, it is essential to acknowledge, as Hannah Arendt has done, the extent to which he was a product of his intellectual discourse, which had begun in Europe at a much earlier point. Patricia Springborg, for example, has also noticed that Marx's worldview developed in a way that was deeply influenced in his education, steeped in classical learning, which he received as a student in Germany. In addition, classical antiquity was not merely a platform that provided Marx with ideas in his youth. It continued to be a source of ideas throughout his life, as well as is evidenced by his engagement and re-engagement with various authors from Greece and Rome. Now, it's important to note, of course, that Marx never wrote or published any works about Greece and Rome as such after his doctoral dissertation, in which there is some things about classical antiquity. But as people have pointed out who are scholars of Marx, he constantly read and reread classical authors, usually in the original, revising the history of Rome under the Republic in the mid-1850s, and also reading about Appian on the Roman civil wars in the original Greek. He also read and reread Thucydides, as far as we know. So he was a man of his time who was very much influenced by Greece and Rome. So Greece and Rome played different roles, however, in Marx's initial thought. Greece and her philosophers, such as Plato and Aristotle, is more frequently mentioned in Marx's works than Rome is. Rome is mentioned less so, but at the same time, Rome and the Roman legal system and its importance for Germany at that point played a different role, and as I hope to demonstrate today in my paper, a very important role in the development of Marx's worldview. So this is because Marx used Greece and Rome differently. He used Greece and Greek philosophical understandings specifically to critique in that very humanist way political and economic problems of his own time. Thus, the focus of my paper will not be on the Greek philosophy side of it today, because I have only a limited time, but I would like to talk about the impact of the Roman legal tradition on Marx as such. Now, the next bit might be a bit gauche, because all of you know this history better than I do, but I will just very briefly talk about Germany. So the nation state of Germany, in its current configuration, of course, is a product of a much later period. Germany of the 19th century was still quite a different scenario, both in terms of its constitutional structure and also its geographic boundaries. As any student of European history knows, the main reason for this is, at least initially, the fate of the Holy Roman Empire on the one hand, and then subsequently the rise of the Kingdom of Prussia. And those are the two factors that influenced Germany in the 19th century and beyond. So by the start of the 19th century, Germany consisted, as we all know, of a loose patchwork of different states, primarily princedoms, but also bishoprics, each with their own national laws, drawing in various degrees from the medieval jus commune. And the core component of the jus commune being Roman law, or canon law versus Roman law. So during the 19th century, and at least from 1815 onwards, when the German Confederation is established, these states are increasingly becoming aligned with one another, and so the issue of unification, both politically and legally, becomes an issue, and a much debated issue in intellectual circles. Now, it's against the backdrop of this debate about unification of state and law that the main protagonists of this chapter will be introduced. And here we start with the first one. Savigny, arguably one of the most famous jurists of the 19th century, was born in Frankfurt am Main, and it was then part of Prussia in the years leading up to the French Revolution. He's born in 1779. He was a member of a minor noble family, and he also received, as we all know, a secondary education that was very heavily steeped and influenced by Greece and Rome, classical antiquity. He then proceeds to study law at various German universities before being appointed the chair of Roman law at the University of Berlin, then the capital of Prussia, in 1810. He occupies this chair for a considerable period of time before finally being elevated to High Chancellor, which is the chief legal officer tasked with law reform in the Prussian royal bureaucracy in 1842. He dies in 1861. Now, during the point at which Savigny is at the height of his intellectual powers, from 1810 to 1842, Berlin was an intellectual hotbed. On the one hand, one had the legacy of the great philosopher Georg Hegel, who had also been a faculty member at the University of Berlin, and the law faculty there consisted of, looking back upon it, a proverbial galaxy of intellectual stars. At the same time, more generally, it was a period of great political and social turmoil, during which Prussian society was trying to come to terms with the socio-political reverberations of the French Revolution of 1789. Now, in modern legal historiography, as we all know, Savigny's name has become synonymous with an intellectual movement, the German Historical School, which played an essential role in the debate surrounding the proposed codification of law in Germany. Although the German Empire would not come into existence until later, its predecessor, the German Confederation, was in the process of progressively coalescing into a single state because of revolutions and wars which all occurred during Savigny's life. The German Historical School, as we all know, is not an isolated ideal. It forms part of a much greater, larger general societal turn in many aspects of German society during this century, and that turn is towards history, known as historicism more generally. Now, while it is difficult to define historicism as such, it's perhaps best to explain that historicism was a reaction. It was a reaction against the Enlightenment that had dominated European intellectuals' discourse for much of the 18th century. The central tenet of the Enlightenment, as we all know and as we heard from David Hume earlier, was that reason, so in other words, scientific reason, could be used to improve the problems of contemporary society. As Nicolas de Carità, who's the Marquis de Condorcet, eloquently wrote, if man can, with almost complete assurance, predict phenomena when he knows their laws, and if even when he does not, he can still, with great expectation of success, forecast the future on the basis of his experience of the past, why then should it be regarded as a fantastic undertaking to sketch the future destiny of man on the basis of history? That's what Condorcet wrote. The sole foundation for belief in the natural science is the idea that the general laws directing the phenomena of the universe are necessary and constant. That's what Condorcet said. And then he says, why should this principle be any less true for the development of the intellectual and moral faculties of man than for the operations of nature? So basically, laws work like natural laws. That's what he's trying to say. Now, the vehicle through which this could be achieved was nature, of course, or more specifically, the idea of natural law, a concept taken from Roman law, where it referred to something slightly different, of course, as we know from the famous quotation about what is the jus gentium and the jus naturale from the Digest, Ulpian's famous comment. Through the Middle Ages and onwards, natural law combined with scientific reason became a very important intellectual force, especially in Enlightenment thinking. During this century, the 18th century, many scholars extensively belabored natural law, and eventually it came to be used as a shorthand way to deduce certain fundamental transcendental values that were compatible with Enlightenment thinking, such as freedom and things of that kind. As Peter Stein put it, and I quote, in the first half of the 18th century, natural law became even more abstract, a series of logical deductions from rational and the social nature of man. And also Peter Stein, the rationalist natural law philosophy proclaimed that a complete set of laws could be stated simply and rationally, with all the complexities eliminated, and all that was needed to enact it was the will of the prince, the will of the lawgiver. Now, so far, Enlightenment thinking. Historicism then represented a reaction against this very idea, and it was a reaction against the idea that human reason is eternal. Instead of propagating the existence of these transcendental values of Enlightenment thinking, often distilled from Greco-Roman antiquity and adapted to modernity, what the supporters of historicism argued was that the present could only really be understood with reference to the past, and that the reasons for the current state of everything should normally be sought in the past. At the same time, what they were trying to do was to elevate history as an academic discipline by transforming it also into a science, using the principles and methods of scientific inquiry formulated during the 18th century, so source criticism and things of that kind. This meant focusing on history writ large, while at the same time acknowledging that human beings were the primary agents of history. Now, coming back to Savigny then, Much of Savigny's tenure at the Berlin Law Faculty between 1810 and 1842 was spent refining this basic idea of German historicism, while at the same time also getting into lots of fights with his colleagues who were not so fond of the idea of German historicism that he was propagating. As one of the most influential German jurists of his time, he was instrumental in setting up the curriculum of the Berlin Law Faculty, in which he fiercely advocated the study and the teaching of Roman law to replace the focus on natural law in the older curriculum. Now, to understand what natural law had become by the start of the 19th century, it is vital to place it in context. By this time, natural law had become an increasingly abstract set of rules, not grounded in any scientific reason or space or time, but instead viewed as transcendental, so immanent. As Fred Beiser notes in his great book on German historicism, during this period, natural law represented things such as the universal standards of reason or impartial tribunal of criticism, through which one could then critique the existing laws of a specific state, and more carefully, the monarchs who created those laws, because of course that was one of the aims. Now, while an admirable idea, the reality was somehow less than the sum of its parts. The decline of natural law towards the end of the 18th century and the beginning of the 19th century has commonly been attributed to a variety of factors, including the growing influence of the critique of Immanuel Kant against pure reason, the use of the concept of natural law to defend the excesses of the French Revolution of 1789, as well as the sheer variations in national conceptions of natural law prevalent across Europe during this time, undermined the core idea that it was a universal law as well. Now, it was against this backdrop that Savigny developed the premises of the German historical school. Many of the fundamental principles underlying German historicism were rooted in the work of a Frenchman, Charles-Louis de Secondat, Baron de Montesquieu, whose De l'Esprit de Loi, published in 1748, had made a very compelling argument against the existence of universal law. However, it's essential to appreciate that Savigny's engagement with Montesquieu is subtle and nuanced. It's not just a copy of what Montesquieu is saying. So, as a specific manifestation of German historicism, more generally, the premises of Savigny's German historical school were threefold. First, he placed great emphasis on the study of history. The current state of everything in the world could be understood if we looked at history. That was his first idea. His second idea is one cannot understand history without focusing in the first place on the society alone and then only upon the place of the individual in society. And finally, the source of all national law, and this is the one that everyone knows today, lies in that collective society. It does not lie in an individual, and it certainly does not lie in the will of the lawgiver. That was the main sticking point. And the latter point has become quite a contentious issue, considering the focus of many Enlightenment scholars on state formation and the relationship between citizen and the ruler. These three premises were underpinned by a very deep skepticism amongst members of Savigny's school towards philosophy, primarily because of its close association with natural law and the Enlightenment, but also in no part, small part, owing to the views of the German jurist Gustav Hugo, seen by many as the true father of the German historical school, and his views on the autonomy of law. As Peter Stein has shown, Hugo was a very enthusiastic reader of Edward Gibbon's Decline and Fall and had translated that chapter on the history of Roman law into German, and thus made it very influential in Germany. This chapter would influence Savigny and the supporters of the German historical school, especially concerning the slow organic development of law. What Hugo thought about Gibbon's chapter was that it showed that the root of the law, much like Savigny would say, does not lie in the will of the lawgiver, but it lies in the slow organic debate of legal principles amongst the jurists. So, it is essential to appreciate that German historicism and the German historical school had both didactic and ideological aims. In terms of pedagogy, so the teaching of law, Savigny championed the teaching of Roman law in the law curriculum at Berlin over the teaching of natural law. But the Roman law that Savigny favored and that he taught at Berlin was not timeless abstractions favored by scholars of the Enlightenment or indeed natural law. Instead, it was Roman law in its various historical contexts, so the socio-economic, the political, the historical, and so on. Although it would be wrong to say that it was completely historicized, because it was taught still with a very sharp nods towards the idea of systematization, and by interpreting the existing sources relevant to Roman legal history, such as Livy's Ab Urbe Condita, Pomponius's Enchiridion, through the scientific approach developed by German historians of the 19th century. So what these Roman sources demonstrated to Savigny par excellence was that legal development could occur much more fruitfully when it occurred in an organic way, through juristic interpretation rather than through statutory intervention. As Peter Stein said it, each nation's institutions, such as its language and its law, reflect this popular character and should change as society changes. Legislation is too blunt an instrument for legal development, end quote by Peter Stein. Now, the motivation for teaching or for approaching Roman law in this way was twofold. First, according to Savigny, if you teach Roman law in this way, and if you teach law more generally in this way, then it had the potential to create what he called an entire worldview that could act as a counterpoint to the complex, challenging socio-political circumstances of history of Europe in the 19th century. In other words, it showed how legal change could occur in a different way rather than just through statutory interventions. In the second place, as Fred Beiser has noted, what Savigny wanted his students to learn was above all what he called a historical sense. In other words, the awareness that law is the product of history and that it has to be interpreted contextually in time and place, as opposed to being interpreted abstractly. So the study of Roman law, according to Savigny, was not approached in isolation, however. It formed part of a much more extensive didactic program which Savigny championed at Berlin, and it is described by the term Rechtswissenschaft, yes, the science of the study of law. Now, while the scientification of the study of law was undoubtedly situated in the more significant movement of historicism, it is essential to remember that it took a very specific form within the study of law. By teaching students Roman law using original texts and exegese, the exegesis of Roman legal texts, they acquired critical and hermeneutical skills, according to Savigny. These skills could then be amplified and also used to interpret modern law, for example, when it came to codification and parts of the code. Now, nowhere is this more evident than in his teaching of what he called the methodology of law. Every science requires a rigorous methodology. Thus, in the curriculum that Savigny created in Berlin, students were taught methodology of law alongside Roman law as the two counterpoints in the German historical school. And when combined, history in the sense of Roman law and methodology in the sense of the exegesis and the systematization of legal text formed Rechtswissenschaft. It's the science of jurisprudence, as Savigny saw it. Now, the debates amongst 19th century German jurists about legal science and methodology formed part of a much larger controversy about the nature of law more generally. As any student of European history knows, the rise of the nation-state in the early modern period, combined with increasing legislative abilities of absolute monarchs, had led to most European states by this time operating a hodgepodge of legal rules, some deriving from custom, some deriving from the medieval jus commune, others articulated through royal legislation. In addition, and given the extensive discussions among scholars of the Enlightenment about the nature of the state and the relationship between citizens and the monarch, there was solid academic support for the idea that the source of all law is the monarch's will expressed through statute. Savigny and his opponents vigorously opposed this issue, since after the defeat of Napoleon at Waterloo, intellectual discussions in Germany had turned to whether a code of law following the model of the Napoleonic Code, should also be drafted in Germany. For even though Napoleon had failed, the Napoleonic Code had come to be seen as a beacon of quote-unquote progress to which other nations could aspire. Against this backdrop, the academic debate between Savigny and his great antagonist within the law faculty in Berlin, Anton Thibaut, occurred. While this controversy has often been portrayed as one between supporters and critics of codification, the reality is far more complicated. As Fred Beiser has shown in his book, both Savigny and Thibaut were in fact what one could classify as moderates. Thibaut's position was that the legal status quo prevalent in the German Empire, whereby law was viewed chiefly as a jumble of different types of rules from different systems of authority, was untenable. He believed that Roman law, whether in its historical form advocated by Savigny or in the jus commune form still operative in Germany, was too difficult a legal system to operate. In addition, it wasn't quite suited to the conditions of 19th century Germany, where industrialization was also starting to take place. Thibaut therefore advocated in favor of the creation of a civil code following the example of the Napoleonic Code, in which the law could be set out clearly and systematically using general programmatic statements. So, indirectly also, Thibaut advocated in favor of law being mainly the will of the sovereign or the command of the sovereign via codification. Now, the notion that codification was the next logical step in the development of law for Germany was rooted in two aspects of scientific natural law thought. The first of these was the notion of progress, a fundamental idea of Enlightenment thought. As, for example, one can see in Enlightenment thinking, I'm just citing one person here, Anne-Robert Jacques Turgot, a famous Enlightenment scholar. He said the following: the phenomena of nature, subjected to constant laws, are confined in a circle of ever the same revolutions. All perishes and all revives in these successive generations by which vegetables and animals reproduce themselves. Time only gathers back in each case the image of what it had made disappear. The succession of man, on the contrary, offers from age to age a spectacle ever varied. Reason, the passions, liberty incessantly produces new events. So throughout the 18th century, this idea of progress had increasingly been refined to a point where stages of societal evolution had been identified. So from hunter-gatherer to pastoralist to industrial to contemporary society, as is, for example, visible in Adam Smith's lectures on jurisprudence. In addition, certain types of law had come to be associated with certain types of human behavior or stages of human society. So, for example, according to some of the Enlightenment scholars, quote-unquote primitive societies operated on customary law, whereas natural law or legislation was the preserve of a developed society. Okay, so this reinforced the natural law idea that codification was the next step, logical step in the progress of the German Empire. The second aspect was that of modernity, a popular trope in Enlightenment thought that took on a new significance after the French Revolution of 1789. In broad terms, supporters of modernity had argued that the 1789 revolution in France was not merely an event confined to France, but that its outcomes, such as liberty and equality and all these things, were universal principles that were unfolding across Europe, indicative of a new epoch of European history, in other words, modernity. Savigny's position, though generally described as being in opposition to codification, was in fact much more subtle than this. For him, as I said before, the basis of the law lay not in the command of the sovereign, but in the spirit of the people. In addition, and drawing upon Roman law, he viewed the Roman jurists as a good example of a class of interpreters who stood between the people, writ large, and the sovereign's will. So they were kind of the intermediary between the sovereign and the people. His attitude towards codification, as we all know, was not entirely favorable, but it was for a variety of different reasons. It wasn't that he was ideologically opposed to codification per se. First, of course, and this is, I think, a very important one, he viewed codification as premature for the German Empire. He said it needed more time to reflect before codification had to take place. Secondly, he thought, and leading on from this idea of intellectual haste or immaturity, he thought that the jus commune had to be further explored first to see what kind of Roman law principles had remained in the different parts of the jus commune of Germany and why that was important. So he wanted to look at the organic remains of the Roman law in the different parts of the jus commune rather than just rushing towards codification. So this is not unimportant, given Savigny is often portrayed as just somebody who was not in favor of codification per se. And as we can see from these two statements, it wasn't codification as much as the haste of the project and the fact that they were not taking into account the existing law that Savigny objected to it. So he was not against legislative intervention in the form of a code, but he did not see it as the solution to Germany at that point. So I think that might also go some way to explaining why, when he became head legislative officer in 1842 in the Prussian ministry tasked with law reform, very little legislation was passed thereafter until his death. One gets the impression that he was delaying legislation because he didn't really like it as a source of law. He didn't think that it was necessarily the thing that had to be done. So when one looks back at this, then it's clear that the debate between Savigny and Thibault is about the debate between tradition on the one hand versus innovation or revolution on the other hand. That's what it's really about. To those in the camp like Thibault, who were in favor of a revolution or innovation, the French Revolution of 1789, and then shortly following on from that, the codification of Napoleon of 1804, was seen as necessary progress, necessary progressive steps in society. But Savigny and his supporters did not support this position. Now, as we all know, Savigny's ideas of slow organic historical development of law was not popular with many people. Even during his lifetime, it was criticized not just by Thibault, but it was criticized by other people as well. For my purposes of my paper today, one of the most exciting critics of Savigny was the German jurist Rudolf von Jhering. Of course, von Jhering is slightly later than Savigny, but the two sparred quite a little bit, whose name has come to be very closely associated with what one would now call sociology of law, I guess. Jhering was a utilitarian in much the same way as Jeremy Bentham was a utilitarian. He believed in social utilitarianism. Between Savigny and Jhering, there were fundamental opposing ideas. So Savigny, for example, Jhering did not see law as primarily an intellectual exercise. He saw it as something which was a social instrument to be wielded to affect legal change. And although Jhering is, of course, in the generation after Savigny, Savigny's ideas, especially expressed through the works of one of Savigny's pupils, Georg Puchta, caused the debate between Savigny and Savigny's ideas and Jhering. And so, yeah, that's where it is. Now, we then come to Savigny and Marx. Now, the intersection between Savigny and Karl Marx is one of the lesser known aspects of Marx's intellectual formation. Karl Marx, his dates are 1818 to 1883. And as we of course know, Savigny dies in 1861. Okay, so there's about 20 years in which Marx is still alive after Savigny has died. So as their dates indicate, they are roughly one generation apart. And a few introductory remarks concerning Marx's intellectual formation are required. As all of you know, those of you who study Marx, people who work on Marx distinguish between early Marx and later Marx. Now, early Marx was interested in philosophy and in law, but later Marx was not interested in that at all. He was interested really only in economics as such. So I'm going to look at early Marx here. So when we look at early Marx and the writings of early Marx, it's crucial, as people have observed, to bear in mind that Marx did not write any work devoted to law specifically. In addition, because Marx wrote so much, it's very difficult to distill any kind of theory of law from Marx's work, because he was just not interested enough in law to have a theory of law. Nevertheless, if you look through his early writings, it is possible to see that he was interested in law and philosophy, and he was specifically interested in Georg Hegel's philosophy. And that, I think, is not unimportant. Now, why is it important that Marx was interested in Hegel? Well, what is it that Hegel contributes to our understanding of modernity? In a nutshell, as we all know, Hegel was a rationalist who was deeply influenced by earlier views, notably that of Immanuel Kant about the philosophy of history. According to Hegel, history is a process in which the mind is guided by reason through events, and while moving through these events, the mind encounters competing ideas, dialectics, that then causes debate within the psyche about what is the best solution to come to. Now, when one idea triumphs over another, there's a paradigm shift. And in Hegel's view, history would come to an end when all the fundamental ideas underpinning the French Revolution of 1789 had fully triumphed, such as liberty and equality. Now, within the context of Hegel's ideas, the formation of the state was an extensive topic on which he focused. And given the broad context of Hegel's views on history and dialectics, his philosophy of the state was very much founded, incidentally, on his knowledge of Roman law and the history of Roman law. And early Marx, therefore, had some sort of interest in this as a result of his interest in Hegel's views as such. Now, to appreciate the more direct link between Savigny and the historical school on the one hand and Marx on the other, there is a very interesting and a very obscure little article that no one seems to have noticed by Donald Kelly, the very famous intellectual historian, who has argued, or he has shown, I think, very convincingly, that Marx, as a student, had begun by studying law. Now, he was a law student in the 1830s, first in Bonn and thereafter in Berlin. And thus he experienced firsthand the intellectual disagreements between Savigny at the Berlin Law Faculty, and then at the height of his powers, and some of his colleagues who did not support the aims of German Historical School, notably another figure, Eduard Ganz. Eduard Ganz dies, unfortunately, very young. He dies at the age of 41 in 1839, and Marx still lives, Savigny still lives on for a while after that. But Savigny and Ganz had big problems with one another, both intellectually and personally as well. Now, before focusing on the details of their disagreements and the impact of this dispute on Marx, it's essential to note that the 1830s, when Marx was a student of law, was a very turbulent time in European history and also in Germany specifically. The effects of the July 1830 revolution in France was reverberating through much of European politics. Social tensions generated by the working classes and their desire to have their conditions improved would continue to simmer until 1848, when widespread revolutions occurred across Europe. The intellectual disagreements between Savigny and Ganz played an essential part in the formation of Marx's worldview. As Donald Kelly has noted, Marx, as a law student in Berlin during the 1830s, would have been taught both by Ganz and by Savigny. Marx was a student, as far as we can tell, in Savigny's first-year course on the Pandectists, and his course also on legal methodology. In addition, he was taught criminal law in the first year by Eduard Ganz, and also attended a later course of Ganz on the Prussian Civil Code as part of his later studies. Now, much has been written about the disagreements between Savigny and Ganz, and it is generally accepted that their mutual dislike existed not just on the intellectual front, but also at least on a personal level. They just didn't like one another. We all have colleagues like that. It's fact of life. On a professional level, even though their disputes had not yet erupted into open warfare, tensions were definitely rising. Now, the source of the professional dispute between Gans and Savigny was twofold. First and foremost, Gans was a student of Thibaut, and thus he supported him in his disagreements with Savigny about the desirability of a codification for Germany. In addition, Savigny and Gans held very different views concerning the value of philosophy to the student of law. As mentioned above, as we know, Savigny and the historical school following Gustav Hugo did not really hold philosophy in very high regard, no doubt also because of their dislike of natural law and its philosophical underpinnings, and argued that philosophy should not play a role in the formation of future jurists. Gans, on the other hand, was a staunch supporter of Hegel and Hegel's philosophy. Now, in terms of their approach to law and the study of law, Savigny and Gans could not be further apart. Savigny's approach was based on the exegesis of texts, which had been practiced in European legal education since the late medieval period. As noted above, it was built on two pillars, namely rational thought and, on the other hand, systematization. Unlike his predecessors in the natural law tradition, however, Savigny also emphasized historical importance. Thus, in Savigny's view, the current state of law could only be understood with reference to its history. Now, by emphasizing the historical component, Savigny wished to inculcate a very specific worldview upon his students and also about the importance of legal history. He wished to demonstrate that the organic growth of law through the geist of the people and mediated by the intervention of the jurists was a much preferable way to develop law than a state that was dominated ultimately by statute law and codification, that is the capricious will of the lawgiver. Because what if the lawgiver is crazy? Or what if the lawgiver is poor or bad? Gans's view of law was very, very different from Savigny. In the Berlin curriculum of Savigny, Gans taught criminal law in the first year and a course on the Prussian Civil Code. Both topics, criminal law and the Prussian Civil Code, were very heavily based on statute law. The Prussian Civil Code of 1794, a textbook example of an overly elaborate natural law code, was comprehensive in its extreme, while the criminal law of Prussia, although not codified until 1851, was already the subject of an extensive debate academically concerning the desirability of codification under the influence of the recently enacted French Penal Code of 1810. Thus, in Gans's worldview, statute was the main source of law, and it loomed large, and the impact of modernity upon law reform, both civil and criminal, was an important consideration. In addition, criminal law was in the process of undergoing a radical transformation in many European jurisdictions, in large parts owing to the intellectual repercussions of the French Revolution of 1789. Given this context, it is hardly difficult to see why Gans supported Hegel's philosophy. Nevertheless, as modern scholars such as Beckmann has shown, his support of Hegel's philosophy was not uncritical. Gans believed that Hegel's philosophy was necessary foundationally, but that it could be improved upon, especially when it came to the socio-political circumstances of 19th century Prussia. Now, the social political circumstances are best described within the context of two prominent trends visible across the German states between the latter part of the 18th century and the establishment of the German Empire in 1871. The first of these is the gradual relaxation of feudalism, and the second of these is, of course, the emancipation of the serfs. And within the context of these two more significant socio-political trends, the July 1830 revolution in France, caused by a variety of factors, including the dissatisfaction of the lower classes with the legal and material considerations of their legal and material conditions, had a tremendous impact on Gans, who was a known Francophile and who was deeply influenced by societal progress which had occurred in France since 1789, primarily through statute law. Nevertheless, Gans was not only influenced by the situation in France, he also visited England during the 1830s when he was a student, and he came to appreciate the substantially negative impact that industrialization had had on the plight of the common person. Collectively, these two events, I think, instilled in him an appreciation of the social question, as it came to be known in Prussian intellectual circles, namely the plight of poor and the destitute. In his lectures during the 1830s, for example, Ganz had postulated that social conflict was inevitable in Europe if the material conditions of the lower classes were not substantially improved by statute. Furthermore, he viewed statute law as the only way to effect this change. Now, there's of course no proverbial smoking gun that links Marx to Ganz, but given the latter's views on social change and the role of law in bringing about such change, it seems to me highly plausible that Ganz's worldview rubbed off on the early Marx. That Marx was affected by the opposing views of the nature of law and its development held by Savigny and Ganz can be seen from a very specific episode that he documented in his own notebooks during his studies. The first of these is an attempt, as Donald Kelly has shown, to write a book on contract law in the Roman law tradition using the methods of the German historical school. This work has not survived, but Marx described it in his own hand as, quote, a very unhappy work, end quote, and he later criticized it as follows, and I quote, the whole thing is replete with tripartite divisions. It is written with tedious prolixity, and the Roman constitutions are misused in the most barbaric fashion in order to force them into my system. That's what Marx wrote. In addition, as Kelly has said, Marx came to appreciate that this philosophical approach, or this legal historical approach, led to a metaphysical approach to law, namely one where the treatment of Roman law was separated from all actual law and every actual form of law, quote. The second episode relates to Savigny's magnum opus on the law of possession in the civilian tradition published in 1803. As is well known, this work brought Savigny immediate fame, and the issue of possession and its nature became an important topic of debate between Savigny and other people, and those who were opposed to his ideologies, such as Ganz. In Savigny's work on possession, he had examined both the Roman law origins and the subsequent interpretations of these texts by generations of legal scholars in the medieval period and beyond. Possession as a legal concept was particularly fruitful as an idea of investigation, since so much of the early history of the Roman law of property is unclear to us. Thus, it was unclear whether ownership in Roman law conceptually arose out of possession, and more fundamentally, whether possession was merely a fact or whether it was something more than a fact, whether it was a legal fact as such. Although widely admired by his supporters, Savigny's work was also severely criticized across various editions, and when viewed in a round, we of course all know that Savigny shifted his positions on various things as a result of the criticisms of this book. The work convinced Marx that his future contributions probably did not lie with the study of Roman law. Kelly puts it in the following way. The entire exercise, so in other words, Savigny's work on possession, was based on the assumption, which Marx rejected, that legal form, by which Savigny meant classification, could be distinguished from content, by which he meant formulation by Roman and modern jurists. Even to the young Marx, this book must have seemed a monstrosity of antiquarian learning, without any reasonable relationship to the common good. So, the third episode relates to a very public and nasty debate between Savigny and Ganz concerning Savigny's book on possession. Although the disagreement between these two scholars had been simmering during much of Marx's time as a student in Berlin, it finally bubbled to the surface in 1839 when Ganz published a very public attack on Savigny's methodology by arguing that he presents what are mere hypotheses as facts. Kelly says Marx sided with Ganz in this debate. As noted by Kelly, in the first place, Marx had come to reject the idea of understanding and still less of legitimizing social institutions within the framework of an arbitrary system of civil law. Secondly, because of his concern with social justice, he could have had little sympathy with Savigny's tendency to justify the entire range of property rights on the basis of the fact of possession, which is to say on the basis of an amoral and irrational state of nature. Towards the end of the 1830s, Marx gives up the notion of becoming a lawyer, and instead he then moves on to philosophy. Of course, as we know, this is not it's not a very successful turn, because he didn't find work as a philosopher either, and then eventually he even becomes disillusioned with philosophy, and this happens towards the sort of 1840s, where he abandons his plans to pursue a career in law or in philosophy, and then he turns to other things. He then turns to journalism, and he also turns to economics. And this turn to journalism was a way for him to look at the relationship between law and social reality from a different perspective. Okay, so this is not the place to enter into a complete discussion about Marx's developed views about capitalism, but it is worth noting that after his initial forays into law and philosophy, Marx turned elsewhere, primarily to the fledgling science of economics, to develop his views further. In the fully developed version of his ideology, law is portrayed in a very negative way, as we know. First and foremost, Marx postulated a close connection between law and the state. Using this idea, he argued that law, and thus by implication all those who practice law, were upholders and enforcers of structural inequalities visible in the contemporary state. And of course, specifically then, he turns all the focus of his critique to wage labor and the idea that the main consequences of capitalism was that most citizens were reduced to wage labor and thus alienated from their labor at the expense of someone else, the capitalist. That is what he said. So, I conclude. In assessing the impact of classical antiquity on the development of Marx's worldview, this paper has focused not on the influence of Greece, but on the influence of Rome and the Roman legal tradition, more specifically on early Marx. As Hannah Arendt has argued, it's crucial to view Marx as a man of his time, steeped in a classical education and participating in a much larger conversation about matters such as the formation of the state, the right of citizens, and the function of law. This conversation had started at a much earlier point, arguably during the 18th century, and was inextricably linked to the European legal tradition. Marx's contact with the Roman legal tradition occurred during his studies as a law student in Berlin in the 1830s. Now, in terms of the intellectual environment pervading the Berlin law faculty at the time, it was a vibrant arena for disagreement between supporters and critics of the German historical school. It is impossible to determine precisely which scholars contributed the most to the formation of Marx's worldview during this period, but what I've tried to argue in this paper is it is likely that it was the views of Ganz, and to some extent maybe also a bit of Jhering, to which Marx was most closely aligned. One thing is clear, however: Marx's opposition to the aims and the methods of the German historical school formed during his time as a law student in Berlin, and it continued to pervade his writings throughout his life. So we should be very careful about law students who become disaffected while we teach them law, because this can be the consequence. It seems highly plausible that his dislike of law as a subject and his views about the instrumental nature of law in propping up capitalist regimes were formed, at least to some extent, during his time as a law student. Thank you very much.
Thank you very much, Paul, for such a stimulating lecture. So we now have some time for questions and discussion. So please raise your hand and I shall invite you to speak. Yes, Ajahn, okay, Ajahn Kittisak and Ajahn Abhinav. Okay.
Thank you very much for your interesting ideas on introducing us to Savigny and Marx and their ideas in law. to my understanding, there are some kind of differences between Karl Marx and Savigny, but they both based their underlying idea in history.
Yep.
Yeah.
Yep.
Maybe I would like to know what is it about Lenin, because he is one who told that who say that law as such is the will of the governing class.
Yes.
Yeah? And this is for what he follows Karl Marx too.
Yes.
Right? As the governing will of the governing class, yeah. Is it not a bit closer to Savigny in that sense, or no, because of the, let's say, materialistic, or no, let's say the maybe due to the materialistic way of interpretation. What do you think? Thank you.
You're right, of course. They both have a view of history. I guess the main difference is that Savigny saw intellectual worth in law, whereas I'm not sure that Lenin saw intellectual worth in the law as such. Instead, he saw it as a problem, because fundamentally there's a difference in their views about human nature. Those things that Lenin and Marx before him postulate is basically just that people are selfish. It's the kind of Enlightenment thing about people are selfish, and if they get into a position of power, they will abuse power, and so they will use whatever means they have to abuse that power, including the law, if they can. So, whereas Marx and then Lenin see law as nothing more than a facade or something that people who are in power use to suppress other people. For Savigny, because of his understanding, I think, of the idea of law as a science and as an intellectual idea or a concept, he saw intrinsic worth within it to try and maybe deal with the problems that society was having in a sort of roundabout way during that period. Because this is the idea of the world view that I talked about, that Savigny wanted to introduce to the law students there. He thought that if you taught law in this kind of, I don't know, as an entire world view, maybe you can maybe it spreads the idea of order as opposed to the chaos that's going on around you. I know that's not a complete answer to the question, but I think that's probably the best answer I have.
We'll follow up with
sure.
With a short remarks.
Yeah, sure.
If we put it this way, that the idea of Karl Marx and Lenin is based on the idea of people spirit, but in the sense of governing spirit of those class of people, then they will be the same. But the difference is maybe that Karl Marx look into the political effect of the will, but Savigny look at the scientific effect of the will.
I think so, yes.
Thank you.
Yes.
Perhaps we can turn to Ajahn Apinop.
Okay. Thank you so much, Professor, for your illuminating lecture. I really enjoyed it. And I really like the idea about the methodology of law in Savigny's case, because when I try to connect the idea of history and historical understanding with the scientific methodology of law, I feel a kind of conflict there, because then you see that could legal methodology be eternal and universal? And if that's the case, then legal methodology should be different in each historical context, but I'm not sure how to deal with that right now. So I'm kind of curious. And then to think about the idea of scientific methodology of law, I'm also curious if Marx would agree that there's a kind of scientific methodology to the law, at least as an instrument that you could work on it to achieve something. But I kind of think that Marx doesn't believe in any systematization or rational thought in the law. It's just a facade, just as you said.
It's the internal view versus the external view of law, isn't it? So Marx just doesn't see any value in it in a scientific sense other than as an instrument of oppression, So it's very starkly legally realist, almost nihilist, in that kind of sense. Whereas Savigny sees the core of it internally. Methodology, oh dear. I mean, I've spent my entire life so far writing about methodology in some sense or another, and I agree with you that the relationship between the study of doctrine and the study of history or legal history is not an easy one. I mean, it's the fundamental fault line between the internal view of the law, the doctrinal view of the law, which is the internal one, and the external one. So it's that famous debate about internal legal history versus external legal history. And although a lot has been written about that in German literature specifically, I think one needs to be very careful in attributing that very stark divide between is and ought, or between internal and external, to the Romans. It is not a Roman distinction. That distinction between is and ought comes from Leibniz. And so it might be true for everyone after Leibniz, and therefore might be true for German scholars of the 19th century when they talk about the distinction between law and fact. But it is not a Roman distinction, and it is definitely not an early modern distinction. So the Romans had a much more blurred vision of the relationship of law to fact, and there wasn't a clear, watertight divide between those two things, because their theory of law, I'm not convinced the Romans had a theory of law, but if they had a theory of law, it's naturalistic. But naturalistic not in the natural law sense of later times, naturalistic in the Stoic sense of living according to nature. One needs to be careful about that distinction. It's not a Roman distinction. It comes from Leibniz. Yeah.
Yes, please. Ajahn,
Thank you very much, Ajahn Kongsatja. Thank you very much, Paul, for this very enlightening lecture. I was really following very interestedly. I think there are many also Latin terms that students sometimes understand. For example, nullum crimen sine lege, which is nothing Roman, or nulla pena sine lege, but I think Feuerbach came right. So I think 19th century has produced a lot of Latin terms which are not Roman. But when I was following your lecture, which I really enjoyed, I just wondered, is the title Savigny, Marx, and the Nature of Law misleading? Because from your lecture, I just got the impression that Marx was strongly influenced by Gans and maybe Thibaut, and maybe it was a negative influence from Savigny.
Yes.
So you basically mentioned how he was so impressed by Gans and by his thoughts, perhaps, about how the law can be mobilized to help the lower classes and to some way create more equality, following thereby apparently also Thibaut's, who I think was in Heidelberg actually, Thibaut. And who was basically then advocating for that. So to me that sounded as if Marx was impressed by those, and then perhaps Savigny, okay, you may say Savigny was the trigger for Thibault and Gans to then emphasize the spirit of innovation and progression, and maybe distance themselves from Savigny. But wasn't it? I mean, you also mentioned that Savigny was basically a traditionalist who was a bit even against the trend of time. So weren't Thibault and Gans those who were following the general trend of believing in social progress and in moving the spirit of the French Revolution further, while Savigny was actually the traditionalist who was somehow slowing things down that others wanted to push forward. Yeah. So wouldn't that mean that basically Marx followed more Thibault's and Gans' ideas and used Savigny basically as someone to use as a counterpoint? Yeah. So I was just thinking whether Savigny, which I found quite interesting. I mean, you may still argue, because Savigny was such a towering figure, that basically everything goes back to Savigny, and we may then connect many formations of opinions of others to Savigny, because he was just, you may say, the crystallizing point of so many views. Yeah. But whether it, so I'm just trying to ask whether your core argument here can be worked out more clearly how Savigny was the one that can be connected to Marx's formation of ideas, or whether it's not Gans and Thibault.
Titles are always very difficult things, especially when one has to come up with them, in a sort of, I fully take your point, and you're right, of course. Savigny is is the not, I would not say the straw man, but he's the traditional figure, right? I formulated my title in this kind of way because I think that in a way, of course, you're right. It's a much larger debate about traditionalism versus progress, if you want to call it that. And Savigny represents traditionalism, and the other people in that debate represent progress. And Marx, of course, follows the progress thing, the progress side of the argument. But I don't think one should necessarily, and this is not what you've said. I wanted to spotlight Savigny because, as you say, he's such a towering figure, but also because everything that happens subsequently is a reaction against Savigny. It's a reaction against what he thinks about law. It's a reaction about his views on the nature of law. And those people who are opposing him, they're opposing him for very good reasons. And then Marx comes along, and as we all know, when we were law students, there were members of faculty that were very obviously not fond of one another. And made their views very clear in meetings and so on, that they didn't like one another. And I think it's not impossible to argue that that debate triggered Marx into appreciating that his future does not lie in law or later in philosophy, but that he needs to do something else. So yes, of course, he's a man of his time, and he's moving with the times, and he's moving in the sense of, forward to look at other aspects of law. And the much larger point is about the 19th century and early 20th century being the rise of the social function of law, right? And so this story is also about the rise of the social function of law, and there Marx is very influential, as will the legal realists be later on in England, in America, and so on and so forth. But so the point here is, I guess one could say, okay, well, it's about Savigny and Gans, but it's about Savigny and Gans and Marx absorbing their problem and it influencing him in his formative years to move away from law. So yeah, that is.
May I make a kind of a remark on this point? I think both Savigny and Karl Marx, they are addressing the same idea to the progress. At that time, it was a time that there are a struggle for more justice.
Yes.
Let's say between the East and the Ought.
Yes.
And Thibault and Kant, Karl Marx fight for the Ought.
Yes.
Through codification.
Yes.
But Savigny fight also for the Ought, but he don't say that.
Yes.
He just say the Ought will come by the East.
By the East, yes.
And the East will become the Ought by interpretation, by the legal methodology. And he combined it by the being and the becoming in the same through the interpretation of law, according to historical school.
I agree. And of course, there are many things about Savigny's model that remain unexplored, really. I mean, the whole idea of the Geist of the people is, how do you make that work? Really, the idea. I get what he's trying to do. I mean, it's a remark that should be read in the context of law is not about the lawgiver enforcing their will upon an unwilling people. It's in a sense a reflection of the Roman idea of justice, which is based on consent, right? At the bottom of use is consensus. That's very obvious that that's the Roman way of going about it. So it's an extrapolation of that idea. But, the will of the people, it's difficult to express the will of the people if you don't have a mediating factor like the jurists. And that's kind of what he says. The jurists are the filter through which all these chaotic ideas of society are mediated into law. And that is a much better way of having the law develop than, just a random statute that the king has decided is a good idea for whatever reason.
That's really interesting point. Let's also hear from Ajahn Kem Tong.
Thank you very much. So I think this is, my point might be overly simplistic, but is that, so can we say that this is a dispute or disagreement about a pace? I mean, like Savigny is kind of like gradualist, so they are more traditional and rooted in historical like thought, and Marx, for example, is a kind of like a reformist. So they are looking at nation building. That's the same thing, but at a very different pace. And if that's the case, maybe this can be fit into like other nation building scenarios elsewhere too, not only in Germany. That there's always like some parties that want to go slow and some parties that just want to be like go faster or be more, how you call it, cosmopolitan. Like you look around and you want to do more transplant, and then you have someone who says you have to put it in a context. So you have to like be more careful and you cannot be too radical, that kind of things. Thank you.
I think so. Yes, I think on some level. So the whole of the 1830s up to the 1848, which is, the year of the 19th century. It's a bit like 1967 to European eyes. Yes, 1848 is a very turbulent year, and I don't think one can discount Savigny's calls for slowness and graduality and things of that kind as being a reaction against all the turmoil around him, right? I mean, if one wants to do a historical comparison, it's not dissimilar to what Cicero is doing in the late Republic. I mean, Cicero is basically saying, hang on, we can save the Republic. Yes, if we just everyone calm down a little bit, we can save the Roman Republic. But people are not listening to Cicero, and there's just this momentum which is building on all of these warlords who want to just crash everything. So I think Savigny's position is intellectual, yes. I mean, it's a good idea to stop and pause and reflect and take from the history what we can take from it. But I think it's also, to some extent, a product of this unsettledness that is going on constantly around them. You know, there's the French Revolution, then there's another revolution, you know, then there's peasant revolts everywhere. It's a very difficult period to, I think, to be a law teacher during that period because of the unsettled nature of society around them. So yeah, it's about pace on some level. Yeah, it's a much more complicated debate, I think, than people may. It's not just about code or no code. You know, it's a very layered, complicated philosophical and other debate going on.
Yes.
Yes. Thank you so much. So, as you mentioned about the book of Savigny on the possessions, and is related, I think it's related to the criticize of the Marx in later, right? So, could you explain more about why the book of Savigny on possession is significant to Marx idea? Yes, about it. Thank you so much.
Thanks. I've got a little bit here. Let me just. As we all know, you know, for all Savigny's statements about fidelity to history and the importance of history, what Savigny does with history and with the Roman legal materials is often quite, shall we say, creative. 19th century historicism wanted to make history into a science, and the scientific ideals of history that German historians were debating, such as Leopold von Ranke and so on, was all about trying to be as closely to the interpretation of the text as you possibly can, you know, to give an account of what really happened, as opposed to these kind of waffly philosophical speculations of the natural law doctrines or natural law scholars. But this is very difficult for a book such as Possession, in Roman law especially, because we have nothing before the last 2 centuries of the Roman Republic. We have absolutely nothing. And while we have the 12 tables, right, what happened between the 12 tables and the last 2 centuries of the Roman Republic is completely lost to us. Now, we have some vague comments that one can find in Roman annalists, so Roman historians, about agrarian legislation and the Gracchi brothers and things of those. But those are stories, and they are stories that have been fashioned ideologically to create a certain narrative by the historians who wrote them. And so I think Marx's problem was just that Savigny was telling a story that could not be verified. You know, all that we have is the information of the jurists in the digest, which cover, you know, a very specific period. And then we have some stuff in the 2 centuries prior to that based on Cicero and maybe some of Cato and stuff like that. But between what happens in the last 2 centuries of the Republic and the 12 tables of 450, there's an entire complete gap in our knowledge. And it is unfortunately exactly in that period that these crucial ideas of possession and ownership start to crystallize. So it's like Schrödinger's cat. You know, something is happening in there, but we can't open the box, and we just think that the cat, the cat is alive and the cat is dead while we don't open the box. We would love to know what happens in that crucial period, but we just don't. And I suspect that was also what Marx objected to when he says it's about presenting hypotheses as facts, because Savigny's position is that ownership arises out of possession, right? That's the very celebrated thing. But there's a problem with that text. So I can call up the text for you. It's one that I look at quite often in the digest. So basically, it's a text in which one jurist is quoting another jurist about the origins of. Oh, yeah. Sorry. Let me just call up the Latin text. It's digest 41.2.1.1. It's Paul book 54, sorry, ad edictum. And it says dominium of property arises ex naturali possessione, so out of natural possessions. And then it cites a guy called Nerva Filius, which is a very obscure little jurist. And he says, one can see vestiges of this still remaining from the fact that whatever we capture on the sea or in the land or things of that kind becomes ours by first taking. So that's basically the text. And that is the entire basis of Savigny's argument. This one statement that dominium comes from possessio. And it's a point of view. Yeah, it's a point of view that Paul cites with reference to an earlier jurist, Nerva Filius. But where does this come from? I mean, and if you think about it logically, it's not a very strong argument to say that occupatio is the basis of ownership. Other scholars subsequent to Marx, to Savigny, have pointed out that it cannot be what really happened, because this type of scenario that you get ownership from possession presupposes a very sophisticated understanding of property. And it also presupposes an idea of occupatio whereby everything should have an owner. And if it doesn't have an owner, then I make it mine by taking it. And that is a very Roman way of going about the world. Oh, we see these other people, we want their things, we take it. Occupatio. It's a very Roman way of looking at it. It cannot have worked that way. It cannot be the philosophical or the historical origins of ownership. There must be something in between that we don't understand or that we have no knowledge of. And I think this is the kind of thing that Marx objected to, taking that text and making it out as if it's the truth, whereas it's a theory. It's a theory based on one text by Paul citing another jurist, Nerva Filius, not even the proper Nerva, Nerva Filius. Who knows where he got it from? We don't know. So it's that one text, and I think that's what Marx objected to, this idea that passing off very slender historical information as truth. Wow. Yeah.
So we've got a question from an audience online. So he was curious about where German Romanticism fits into this story, if you may clarify.
It's part of historicism. So German Romanticism is also part of historicism. It's part of that sort of broader ideal of looking at the history of the German nation and where, where our own customs and things come from. Yeah, it's trying to root it historically in a specific period.
Yes, please.
Thank you very much for your very, very articulated and interesting talks. I'm not a legal historian. I teach public international law. I'm just interested in the topics. And I wonder how I mean, apart from this story, how do you think law professor should use history in when we teach either the system of law that we have to teach, or when we teach the methodology of interpretation? So those are, I'm not quite sure if that's what you plan to ask later. Okay. So if that yes, I would really, I'm very curious about how do you approach, I mean, as a legal historian yourself, how do you approach the historical facts?
Paul, if I may build upon from Chitti and also like I use a privilege as moderator.
Sure.
So I think there are two during 70s and Marx time there were two backdrops. First, debates on the relations between law, juris, legislators, and social changes. And the second backdrop is tradition versus modernity. Should we break from modernity, or should we go hand in hand with modernities? And I think this is probably recurring debates that we are dealing with these unsettled societies, if you like. So.
What do you mean by we? That's, I think we want to clarify on that.
We abroad the context in a global context and local context, of course. So my question, it brings to my question that how can we learn from those figures to understand law and legal and social changes?
Ooh, not easy questions to answer, but I will try and answer them. Firstly, in terms of system, I emphasize system quite a lot to my students, because somewhere during my 20 years of teaching, I've come to the conclusion that students regard system as almost the gospel. So they don't question the system. So it's taught to them as a system, and then they just absorb that system, and so, you know, it's the system. But once you start pointing out to them that the system is a product of a specific period where people had specific intellectual anxieties that caused them to create that system, then they start to become a little bit more aware of the fact that a system is not unchangeable. And that heads off a lot of questions, I find, about categories as well. So the Roman categories, legal categories, and the Roman system, in as much as there is a system, is inherently fluid. The entire point of showing the students the institutional scheme of Gaius, persons, things, and actions, is to show them that this system is constantly evolving. Even Gaius changes his mind, you know, in a later work, and then Justinian again refines it for a fourfold and a threefold. And so once students start to appreciate that both system and categorization is fluid, they stop worrying about things such as numerus clausus, because a numerus clausus and so on and so forth is usually imposed for very specific doctrinal reasons. And the Romans did it too. So, for example, they didn't expand the category of res mancipi. They could have, because they came across other things which looked like res mancipi, like a camel and an elephant. But they said very clearly, we're not going to expand the concept of res mancipi because it's nonsense. You know, it's a burdensome category that we will not expand. And so they just said, well, these things are not res mancipi. They look like ones, but they're not. So traditio is fine, you know. When you show them that kind of stuff, then they start to appreciate their own system a little bit more, and they start to think more critically about the fact that what they're being taught is not natural law, right? It's not natural law. It's a living organic thing that moves around. And yes, we might need a new category for something, then we make a new category for something. Why can't we make a new category for something? If, you know, just because Gaius didn't have this category, it doesn't mean that we can't make a new category for something. But we need to think carefully about why, you know, and how to do it. Don't rush into it. Yeah. So, yeah. Okay, sure.
Yeah, I totally agree. I mean, I teach public international law, and for that I have to explain, right, why we have the law as it is, why we have UN system today, and this might be again the flow system as we had before. And at the same time I also teach the tech law, which is trying to make sense of the old category to the new thing happening. And of course my students are all confused in both subjects. But just to build on what you said, that okay, it is good enough to let the student know that they can appreciate the change and they see the possibility of change. I think the next question that we got a lot from the students is that what should be the role of the lawyer? Should we be the part who lead the change, like some of those figures today have said, or should we be the one observing the dialogue of the society and we identify what are the consensus of the society? I'm not quite sure if we can use just communicate there. And what you when you explain about those debates, I was thinking about some U.S. Supreme Court decision. That one was the one about same-sex marriage, where the dissenting opinion said about the judge shouldn't be the one who pinned the winning flag here. It should be left to the legislature. So I'm not quite sure if this is something that we should also think about, or how I just want to know, how do you approach this, and how the conversation with the students who will become the next generation lawyer happen in your from your side.
So in my law faculty, we adopt a fairly Germanic approach. You might be interested to know, and the German approach is that every law student that leaves the law faculty should be trained as, I think I might be wrong with this term, but as a full jurist. Yes. So in other words, everyone that should leave our door as a trained lawyer should be able to become either a very small town practitioner of law or the judge president of the Supreme Court. So we should give everyone the same skills so that you can do either of those two jobs without having to do more training. Okay? And in that context, I think it's important to have a conversation with your students about what the role of the lawyer is. Now, in my own field, the Roman jurists played a very specific role, and the Roman jurists have a very specific role to play in the development ideologically of the Roman legal system. They are, of course, increasingly also part of the bureaucracy towards the end of the Severan jurists and beyond. So they fit into the bureaucracy, but I don't think they should have just one role. They can have different roles in different societies, depending on what the traditional role is of jurists in your system. The important thing is that you should instill in students a desire to make a difference. Yes, and no matter what they do, whether they become lawyers, whether they become legislators, whether they become Supreme Court presidents, they should understand that law is about solving problems, and we should strive to solve society's problems in whatever way we can, because that's ultimately why we're there.
Probably one more question from Ajahn Lessa, if you like. Perhaps two then.
I just want to come back to the question.
I've not answered. Sorry. No, go.
Just want to come back to the question on the work of Savigny on possession.
Yes.
I think he make a very good proof. As Jelinek said, it is the normative force of the factuals.
Yes.
Yeah. Possession as such.
Yeah.
Is that.
Yeah.
The all development from the Roman time to today shows us it is the normative force of the factuals. Yeah. And following that, it is the nature of things, of the possession. Yeah. And also to the dominium, to the ownership. But Karl Marx look also almost the same, following maybe Gibbon and Montesquieu and so on, but he come to let's say he comes to what Yearing later said, law and the right is the result of the struggle. In the word of Marx, is the class struggle. In the word of Yearing, everybody struggle. But it is the same thing, but with different aspects.
Oh yeah.
Thank you.
Well, thank you very much, and I'm sorry to interrupt again. Final question. I'm just curious whether you have any information about this. So, Savigny, I think, was very concerned about codifying private law at that point, not only because he was perhaps thinking that it was too rushed, that it was not yet ripe, or that the time was not yet ripe to do it, but I think he also was aware that once you put something into law, it's very difficult to change it in the future or to make any amendments, as we can also see in many other, I mean, maybe that also connects us here to Thailand, to make changes to laws. It's always very difficult, and many scholars of Thai private law may say, well, there are many things in the Civil and Commercial Code that may at some point need to get changed, but it's just not realistic. It will somehow not happen. So if Marx was advocating maybe along Thibault to rush maybe to a codified private law and to work with statutory law as a tool for social change, was he not aware of that danger, that once you put things into law, it might also be very, very static and may not be very flexible anymore, and then it cannot be adopted or adapted to social changes? So I'm generally also thinking that what Savigny was promoting was quite wise, to basically say, well, we should first of all be careful, and then we should also leave many things undefined so that it can be evolved over time, so that we're never stuck with something too much. But Marx should have seen that too, shouldn't he? So is there any evidence that he was also thinking in these categories?
Not that I've come across. I think he hopped from one thing to another intellectually. You know, and once he stopped thinking about something, he didn't really reflect back on it other than to critique it. It wasn't clear to me that he was a good law student. You know, that he, in the sense that law was something that he reflected on a lot later on in his life after he turned to economics and things of that kind. I think he basically just wrote off law as a societal force and saw it as not something that he was going to talk a little bit more about, you know.
Right.
Just to answer the question about fact and law, yeah, I mean, historical fact and normative law, the is-ought problem is the sort of classic issue about concerning modern law. I'm very much there influenced by the German social-legal scholar Niklas Luhmann, and Luhmann's systems theory kind of worked very, very well. Maybe not so much for first years, but you can explain it in a way to first years that kind of makes sense. All legal systems consists of institutional facts. Institutional facts can become legal facts if the law takes notice of them, you know, and then they become law. So it's a way of explaining how, you know, fact becomes law. It's that kind of age-old thing about what is the distinction. But to say that fact is one thing and law is another, and there's nothing in between, is, I think, dangerous for students. So I always try to use Luhmann to kind of explain to them that, you know, there is a connection between law and fact. Yeah. So.
Right. I think, thank you for fruitful discussions, and thank you very much, Paul, for a truly inspiring lecture. And finally, thanks to all of you for your thoughtful engagement. I wish you have a very pleasant afternoon. Thank you.